Hello there, everybody. Welcome back to Legal Talk. I am your host for the show, John Mitchell, and we are very privileged, very pleased to have with us today, attorney Mario Varela. Now, Mario has a wide, varied background. He was an engineer before he became an attorney. Been a lawyer here in Houston, Texas area for a little, right around a decade or so. And also, Mario has a master in business administration. So you're going to want to buckle up and pay attention and see what Mario has to offer for us today. And we're very pleased and thanks very much for being with us today, Mario. Welcome back to Legal Talk.
Thank you, John. Thanks for having me.
Yes, sir. All right. Well, jumping right in, we're talking a little bit today about contracts and contract law. So, number one question that folks have sent in to us, and we want to be sure and ask the expert about this one. So, what are the essential elements of a legally binding contract? How do I know if this agreement that I have is legal or not? Is it a contract? Isn't it a contract? What can you tell us about that?
Well, the most important thing I would say is what's called agreement of the minds, which means we discuss things and you and we are in agreement of what's going to be done. And if there's for any reason something that is we didn't agree to, that's when problems may start. But initially, a contract starts with an offer. Somebody comes with an idea and presents the offer to the other party. The other party can make a decision, can accept, reject, or reject the offer. They can make a counter offer and so on. They can be going back and forth. And the next critical phase step in the formation of a contract would be acceptance. There has to come a point where somebody accepts formally the contract. And sometimes people could argue, well, you never said no, so I assume you were meaning yes, but that's something that's up for debate also. Those are the kind of things that are get discussed when there's a problem later, when there's non-performance. Well, I thought you never said no, so I was counting on you. And the other person, well, I didn't say no, but I never said yes. So that's when problems start. There's also what's called mutuality of obligation. Normally, the obligations are mutual, meaning somebody has to, both parties have to do something. There's no sense, or maybe I should say, a contract would probably be invalid if only one party is required to perform and the other party is not. So really, I mean, it could be paying for services, it could be both parties doing certain things, and so on. But normally, both parties have to perform, do some sort of duty or something, or pay for something. The next requirement, of course, is competency and capacity. This is essentially the person needs to be above legal age, above 18. And they also need to have in good health and mental health, especially, to be able to get engaged into a contract. And there's occasions also other components that are required to be met in order for the contract to be valid. So there you have it. There's a number of things, and the most important thing in summary would be agreement of the minds. Both parties agreed that something was going to be done. The next thing to consider would be whether a contract would be in writing, has to be in writing, or oral contracts are valid. And the short answer is the oral contracts are valid for most purposes. For certain things, they are not. For example, real estate transactions need to be put in writing. Things that are going to last over a year, they also have to be put in writing. And there's a number of situations which require documents in writing. However, many times verbal agreements are okay. We just need to, of course, be able to provide some evidence if we get to that point of what the whether there was an agreement, a contract or not. By the way, the words agreement and contract legally they're the same thing.
Yeah, yeah. I mean, you hit the nail on the head with the meeting of the minds thing because I remember reading a case about two farmers. They had an agreement for, transferring ownership of the spotted cows, and one, farmer interpreted that to mean the white cows with the black spots, and the other farmer thought it was the black cows with the white spots, and then calves were born, and all kind of chaos ensued because they did not have a meeting of the minds. And so, very important. And that is why, folks, it's very important if you're going to enter into a legal contract, you're going to agree with something that's going to cost you money, you better make sure that you have Mario on your side so that he can make sure that your contract is drawn up properly and make sure that you're not going to be like the farmer with the black cows and the white spots, because then you're just going to end up in litigation, and that's when the lawyers are going to take all the money in the end. So and make sure that you protect yourself up front, which leads me to my next question. Let's say, Mario, hypothetically, right? Let's say if I'm a businessman and I want to negotiate a contract with another businessman, what kind of things should I have in mind to protect myself while I'm going through these contract negotiations? What kind of minefield should I be worried about not stepping in? What can you tell us about that?
Well, there are two things. One of them is making it a comprehensive contract, which means anticipating all the things that could possibly go wrong, all the misunderstandings that could possibly happen. And the other thing would be if the original contract was written by, or proposal or offer was written by an attorney. I think it's important that before signing the contract, the other party retains an attorney who will review the legal requirements. There are so many things, and of course, there are terms of art, and there are certain legal definitions and things that are not common English language that can be. Sometimes we don't even pay attention because they don't sound familiar. We think they mean one thing, they really mean something else. So that's why we really have to be careful, especially when there's another attorney who got involved. So that's why, especially, and the attorney will also start looking at all the possible things that could go wrong, all the possible scenarios, all the what ifs, all the things that in the future could derail the good intentions of both parties. And those need to be not documented, discussed up front, because when the time comes and unexpected situations come up, we want to be able to go back to the original agreement, the original contract, and see what we have thought about that, how we handle that situation.
Right, very important. Now we have about 3 minutes left, so I got one final question. Let's say, despite your best efforts and you've tried to do a fair contract that represents what everybody wants, but inevitably, human nature being what it is, dispute comes out, right? So something happens, there's a lack of performance or whatever. What kind of steps should you take if you feel that you're in a contract and then there's a dispute in that contract? What can you tell us about that?
Well, the first thing would be, of course, to try to work things out by speaking, talking to your party, and just going over the differences and see what's working, what's not working, and trying to find a solution. And if the parties are not able to get come to a solution, then the next step, of course, they can always file a lawsuit. But some of the realities about filing lawsuits, they're time consuming. They can run for months or sometimes even years, and in the meantime, it's difficult to maintain the status quo. Some businesses may be affected, that they're not able to continue working because there's a dispute. So there's other avenues that may be a little faster, may help to resolve disputes. And even the judicial system, many times the judges, they will direct the parties after the lawsuit has started. They will direct the parties to go to mediation. Mediation is a process. It's called an alternative. It's a form of alternative dispute resolution, which essentially has an intermediary uh, that's helping both parties discuss the problem and find a solution. This is something where both parties do it voluntarily, and voluntarily they can come to a solution that works for both parties. And if that works, well, they can write an agreement, mediated settlement agreement. That's the way it's called, where both parties explain how they're going to resolve their dispute. It could be some sort of compensation, reimbursement, promises to do something, and so on. So that's a very common uh, method of alternative dispute resolution. The other method also available is to go through an arbitrator, and that is similar to mediation, except that at the end of the arbitration process, it will be the arbitrator who will be making a decision. And normally those decisions are binding on both parties. It's difficult to appeal them, but that makes the things go much faster. The reason I compare that to the judicial system is because once a lawsuit is filed, then there comes, first of all, serving the other party, and then notifying the other party there's a lawsuit against them. Then normally the next step is going into discovery, which means exchanging evidence. After that, they may be calling in experts. After that, the judge may order mediation, and only if mediation doesn't work, then the judge will agree to listen to the case, hear the case, and make a decision. That's why it's a much longer process. And of course, when you're in court, it could go either way. You could get 100% of what you're asking or 0%. So that's why many people try to hedge their bets and go to mediation where they will find a solution, and hopefully something they can live with, something that both parties agree to. I mean, nobody's going to be happy or nobody's going to win everything in mediation, but at least the dispute is resolved in some form or fashion, and both parties are able to move on. So those are some of the ways to resolve contract disputes.
Perfect. Well, folks, there you hear it, straight from the fountain of information himself, my good friend Mario Varela, a lawyer extraordinaire right here in beautiful Houston, Texas. We are so pleased to have Mario and thank him for being with us on the show. And one last thing, Mario, if you can, let people out there know how could they get in touch with you if they want to get their disputes handled before they become a dispute. How would people find Attorney Mario?
Yeah, we'll be happy to assist. We're main number is 713-684-3550, and our office address is 8554 Katy Freeway, Suite 340, Houston, Texas 77024.
Beautiful. Well, again, Mario, thanks very much for being with us. We really appreciate your time and your expertise, and we would love to welcome you back for future episodes of Legal Talk. And have a wonderful rest of your day, sir.
Certainly. Thank you very much. Thanks for having me, John.
Yes, sir.